Hello, and welcome to this discussion event hosted by junior labour lawyers. The topic for the discussion is COVID hygiene in the court estate. My name is Alex Chapman, and I am the Secretary of Junior Labour Lawyers, which is the junior branch of the Society of Labour Lawyers. I'm a solicitor working in criminal litigation based in London. A few weeks ago, at the end of February, the Prime Minister set out his roadmap for the easing of the final national lockdown and a gradual return to normality. If there had been any doubt among legal professionals and other court users about what this would mean for a return to regular in-person hearings, the Lord Chief Justice released a statement on the 17th of March in which he said, quote, "Over the next few weeks and months, as the number of people who have been vaccinated against COVID increases and restrictions begin to ease across England and Wales, it will be possible and desirable to increase attendance in person where it is safe and in the interests of justice. This will be important to maximise the throughput of work," end quote. Many lawyers will agree that in-person hearings are often desirable, particularly when evidence is being considered. Many may have welcomed this sign of intention from the LCJ in the face of, for example, speculation of future use of remote jury trials. But what then about the state of hygiene and safety in the court estate? If we are to return soon to some semblance of normality, how can we be sure that we are keeping ourselves and each other safe? The vaccine only protects the vaccinated from either infection or, and this is the important part, getting seriously ill from COVID-19. It does not stop transmission completely, and we are being generally advised to continue to act in the same ways as before. There is also emerging evidence that it may not protect against some of the new variant strains that are emerging. Measures are being taken and have been taken by HMCTS, including the use of screens and more regular cleaning. And now we hear about piloting of lateral flow testing in 7 Crown Court centres. However, many lawyers and court users on the ground will attest to the picture not being quite as rosy as the MOJ would have you believe. There are regular tales of crowded corridors, jury trials being derailed due to outbreaks, terrible states of hygiene, particularly in the cell areas, and recent news of planned staff strikes at Liverpool and Snaresbrook Crown Courts. This evening, we will discuss the state of affairs as they currently are and what might be done to improve things in the short and long term. We have 4 speakers joining tonight's discussion. Alex Cunningham MP, the Shadow Minister for Courts and Sentencing. Kerry Hudson, a solicitor and director of Bullivant Law and immediate past president of the London Criminal Courts Solicitors Association, better known as the LCCSA. Raj Chada, solicitor and partner at Hodge Jones Allen, which has one of the largest criminal litigation departments in the country. Tomas McGarvey, counsel at Church Court Chambers. And finally, my name is Alex Chapman. I am the Secretary of Junior Labour Lawyers. This event is being recorded, and we welcome any additional questions or observations from attendees in the Q&A section at the bottom of your screen. Finally, to our panel, I am hosting this event, but I mean the word hosting in the loosest sense. This is a discussion among professional court users with the Shadow Minister with an aim of assisting him in pressing the government to do better. Please feel free to speak up at any point. Alex, maybe we could come to you first. As Shadow Minister for the courts, you're clearly very aware of these concerns already. And I think we've all seen and are grateful for your regular written questions to the Secretary of State, requesting more information about, among other things, infection rates in court centres. Could you kindly tell us more about your work in this area and the official responses and engagement that you've had back from the MOJ?
Yes, I'm very, very happy to do that. And thank you for the opportunity to talk with you tonight. I seem to be spending quite a bit of time with labour lawyers. We have the Society working on various amendments and pieces of advice for us for the Courts and Sentencing Bill, which is just coming. Well, we've already had the second reading that will go into committee in May. So we're grateful for all the support that we get. But of course, we're here to talk about the state of the courts, and particularly in relation to safety and the the resultant backlog that it has suffered. And just to remind people that there were 40,000 cases outstanding in the Crown Court system before the pandemic. And that's since gone up well, it's gone up to 57,000 now, according to the numbers I have. And, like everything else, the justice ministers tell me, it seems to, what they say tends to contradict what I understand to be the facts from people on the ground and from their own statistics as well. So I was told that, for example, that the level of infections within the court system were at or below the national average. Well, that might apply to a court here and there, but their own statistics show, and you alluded, Alex, to my written questions of how many cases there actually are. And one of them, and I'm referring to my notes, that between the 24th of November and the 11th of January, there were 599 confirmed cases of COVID in the courts, including 80 at Oxford and 35 at the Royal Courts of Justice. Now, that's a very different picture to the safe environment that Minister Phelps was telling me about on a regular occasion from the other side of the dispatch box. So, we're concerned about that, but what we're really concerned about is that it's justice denied if we can't get cases into the courts. But it's not just that, it's also the issue around victims and witnesses who are called to, appear in court, and they may not be appearing until 2 years, maybe 3 years after the incident. And we know that there are some court listings as far ahead as 2023. So that proves that the system is in crisis. I know I don't want to speak too long, but to me, we believe that there needs to be far more Nightingale courts. We were promised 200. The best we've had so far is that we should have had 60 by the end of March. We talked, Alex, you also alluded to the testing, the COVID testing in courts. Why on earth do we have to have a pilot? Just roll it out, make it happen. We believe that is also part of the solution. And similarly, and I know lawyers don't necessarily agree with us as far as wartime juries are concerned, but we believe that they may well have a role to play at some time in the future. And when you think that, it was who was it now? Trying to find out who it was that got the numbers for us, but more than 3,600 people, a third of England's remand prison population, have been held beyond the CTL limit. According to the numbers, it was Fair Trials who actually dug that out with a freedom of information request. So clearly there is crisis in the courts. As far as COVID secure is, well, the picture, as I said, just as with court numbers, the actual environment is very different according to the lawyers and professionals and others that are working in the court to what the government would have us believe. Other numbers I can give you, in 1 week in January, 160 cases, another week 69, another week 164, and that's across England courts only. And, the government ministers have been given us assurances, left, right and centre, yet when the health and safety executive has gone into some of our courts, they've found out they're actually in breach of the law, never mind the breach of any COVID rules that the government may have laid down. So that is a matter of considerable concern. I wanted to touch very briefly, and we can talk in more detail later, but I wanted to just touch on remote and digital justice, and we're really concerned about the operation of that. We see that police forces are now withdrawing from virtual remand hearings. It's too expensive. It's costing the Met £2 million a year for that sort of work. They're not compensated for that in any way, and so they're getting out of that particular business. In smaller operations in Norfolk, it's £100,000 a year it's costing the police for a relatively small police force. So major issues there, but for us, there's no proper provision for vulnerable people with learning difficulties, and all manner of others within that system. and we're very, very concerned about how that is operating. But I'm hoping that people have got good ideas about how we can next challenge the government. I think the most interesting thing is they say one thing, we ask them for the facts, they provide the facts, and they're totally contrary to what ministers have said at the dispatch box. But we want to keep up the pressure here because we have a duty to you, working in the courts, to make sure that they're safe. So help us do that. Thank you.
Thanks, Alex. Yeah, I was reading some of your written questions just yesterday in preparation for this, and the one that I found quite alarming recently was at the end of January, you submitted a question to the Secretary of State, how many cases of COVID-19 have been confirmed among the A, staff, B, judiciary, and C, users of each court from the 26th of January to the most recent day for which that information is available. Their rather alarming response, which followed a month later, was that there had been confirmed cases in 95 court centres in that month alone, which does rather suggest that measures being taken aren't sufficient. Kerry, perhaps we can come to you. You're a really highly respected solicitor. You're immediate past president of the LCCSA, which is a representative body for solicitors in London. Your tenure as president ran, I think, for the 12 months to November. Is that right?
That's correct, yep.
So that would have encompassed, obviously, lockdown 1 and I think lockdown 2. I guess my question is, what is your view generally on how things are on the ground?
Wow, where to start? Well, obviously, there's no manual for how to deal with a pandemic. So I picked the worst year on record to be the president of the LCCSA. And I think, Alex pointed out, a good overview there of the main points and the main sort of considerations in my mind. But I think what the first point I want to make really is we talk about statistics, but they are skewed statistics because you are relying on people actually reporting outbreaks to the people in the courts. Now, as an employer at the moment, if one of my staff came to me and said, you know what, I've got COVID, I've been to X court this week and last week, I would have to then try and find out what the procedure is, because nobody has come to me and said, this is what you do, Miss Hudson, if this happens in your firm. This is what we do in London. This is what we do in England. It is an absolute free-for-all. And my first point I wrote down before this meeting in my brain dump was the lack of consistency across the estate. And when I was in the hot seat as the president, I felt like a big part of my time was to try and get people to join up their thinking and join up their approach. So my practice is across London, and it just seems to be the left hand not speaking to the right hand. So especially with good practice. So what's working at one court is not passed on to other courts, and that is very, very frustrating. So as lawyers, we've got a role to play there, because especially on Twitter, because we can pass on that good stuff as well as point out the bad stuff, and we're very good as lawyers pointing out the bad stuff, and we spend a lot of our time, especially on Twitter, doing that. But my new approach is where I see good practice, I am trying to share it. So that was my first real point. My second one is that the other thing I've been trying to do is to get people to think outside of the box. So as lawyers, we like our kind of traditional approach, and we look at our court buildings, and we've got these tiny buildings that were never designed for modern technology. They were never designed for many people gathering together. So as Alex said, this isn't a COVID problem. That the problems with the courts started pre-COVID. It started with conscious decisions over many years to not properly fund the justice system, including the court estate. So from my perspective, I'm still an active duty solicitor, so I might be running my firm and sitting as a president, but I also am out on the ground, and I've got both feet firmly in my practice. And what I've seen over the sort of 13-14 years I've been doing this is just a crumbling, both physically and metaphorically, of the court estate. Absolute basics, there were people coming to me saying, this is the state of the toilets in the court, there's no water, there was nowhere to go, nowhere to sit. Gradually, we've been eroded down into nothing. And for me, all that COVID did was shine a massive light on what was already a problem, and it made it a life or death situation, like in the literal sense. So I just wanted to acknowledge that, really. This is something we should have been dealing with well before a public health crisis. And when I say thinking outside of the box, we need to be thinking short term, medium term and long term here. Now, I'm not going to pretend to have all of the answers for you, Alex, as to how we fix our system. That's for another day, certainly not for an hour discussion now. But for the short term, we're coming up to the summer weather now, hopefully. Things are going to get a bit better outside. From my perspective, I don't care where I see my client as long as I can see them, and as long as they get listed, they get processed and they've got access to justice. So why are we not thinking, well, why can't we put temporary areas outside in courts? You know, get rid of car parks. We don't need car parks in central London. We should be cycling or walking or, you know, getting public transport if it's safe enough. We should be having areas where we can see our clients before court. So we're not all congregating in the tiny, unfit for purpose concourses. And we're not having to, you know, have half of the consultation rooms locked because they're too small. They only fit, you know, 2 people in anyway, and under the social distancing rules it's not big enough for 2 people. So, you know, I'm speaking to my colleague today, she's just been to a Crown Court, and I won't name which one it is, and there's just nowhere to see your client. So how do you talk about, you know, a sex case when there's nowhere to speak to that person? You know, so you talk about access to justice, that is an erosion of access to justice, not having timely private access to your lawyer. So I just wanted to put that out there, and I did float back in April last year the idea of porter cabins, because one of my friends was involved in the whole construction of the London Olympics. I know it's a while ago now, but practically the entire site at Stratford, which I can almost see from my window, was like lifted in on trucks through porter cabins. So I don't understand why, as a temporary measure, if we're really committed to sorting out the problem and the delays and the backlog, if the money is available, I'm sure we can get some of these porter cabins in to start getting these cases through. So that's just one of my ideas, and I'll leave it to somebody else to carry on, because I've got a whole load of stuff that I could talk about, but hopefully that helps start off the conversation.
It definitely does, and we can definitely come back to ideas for how to make things better maybe later on in the hour. Raj, maybe I'll come to you next. You're a solicitor, advocate, head of criminal litigation at Hodge Jones Allen. I think I'm right in saying that Hodge Jones Allen has one of the largest, in terms of numbers, criminal litigation departments in the country. You're also, like Kerry, an employer. And I guess I'll ask you the same question. What's your perspective? What's your take on how things have been with COVID?
I think what we find difficult, what I find difficult about COVID is the number of different hats that you wear as you try and approach this crisis. And we start off, I think, by saying we are public servants. We work in an essential public service, and we all work in that sector with that very strong public sector ethos, and we want to keep it going. We want to contribute to that sector. But we work also in the private sector, and our income, for example, has been hit by in excess of a third over the last 12 months. If that position continues, there will not be very many criminal litigation firms left countrywide. And then you will see the consequences of the lack of access to justice. But we simply will not be able to continue in terms of income. And that is an important factor that we're going to have to think about. It's particularly acute in the Crown Court. I spoke to a QC today who'd confirmed that 70% of jury trials in the last 12 months have not been effective. So I think that, frankly, is an underestimate. Certainly, the major trials, we all know, the major multi-handed trials, the trials are just not happening. And it's a death knell for the system. And then we come on to our hat as employers. And this is really difficult, actually. We are responsible for the health and safety of our employees. We are concerned and seek assurances about their health and safety when they go to court. But we have to balance that, frankly, and there's no way around saying this is the truth. with making sure enough income comes in to pay those employees. Because if we didn't have the income from Magistrates Court, we would have gone bust 6 months ago. And so we're being forced into this position and to assess the risk ourselves. I do, and I should have started off, I think, by paying tribute to Kerry and to the work that the LCCSA did over the course of the last 12 months, because they really pushed on that issue and making public the court assessments that HMCTS did. And that was a great deal of work. But we've had to deal with, on a day-to-day basis, do we send our employees in? We've had to develop our own protocols within each firm about how we approach the case. And perhaps we do need to do better at sharing that information. But the result has been delay. You know, the delay is just fantastic now. And I've had a trial recently listed, it was December 2022, for an offence that happened 2 years ago. I mean, this is bonkers, frankly, now, the level of delay. And things are getting slightly better, but there is no way that we're back to normal, and there is no way that the backlog is being addressed. So whilst we're concerned in relation to ensuring COVID safety, there is no prospect that that backlog is going to be addressed, because we're nowhere near getting up to full capacity. I think the Bailey's running at anywhere between 1/3 and 1/4 of its capacity at the minute, because it takes 2 to 3 courts to run one trial. One example of how that's affected us is that we had exactly that position where one of our employees contracted COVID from a client at court. Now, thankfully, she was fine in the end, and it was a mild case. But it creates a level of tension for our employees and for everybody that we're responsible for, and for their own safety. What the courts can do better? Well, smarter use of digital technology. The idea that, certainly in the Magistrates Court, they still can't figure out how to play body-worn footage over a video link. So you either have the body-worn footage on the screen, or you have the video link with your client. But you can't have both. Seems to me to be bonkers. The fact that we cannot use technology like this, we can't use Zoom or Teams or whatever it is, there must be some improvements that we can make just in terms of the digital service that we offer, and ensuring that the judiciary don't go back, that mentions and things like that still take place by way of a digital link, because that's clearly sensible and saves huge amounts of time. But I am going to be quite blunt, frankly, that it's money. There is, I've been through the process. I'm old enough to have gone through, we need better value for less money, better services, all of that stuff. Been there, done it, and I supported it. The criminal justice system is in absolute crisis. And part of that is the court estate, part of that is the other matters of writs of pay and so on. But the reason that we're in this crisis, as Kerry said, is not simply COVID, but it was the austerity program that hit the court service before. There was, I think Alex mentioned, was it 40,000, the backlog before COVID struck. That was because the court system reduced sitting days by recorders by 15% year on year. That's what that is for, and that's why we've got the backlog that we've got. So we need Nightingale courts, definitely. We need porter cabins, but we need courts. And the scandal of Blackfriars Crown Court being sold off 2 months before COVID struck, and then them opening a Nightingale court around the corner, needs to be thrown back at this government at every single opportunity when they talk about waste of money. I think Alex is doing a great job, and I really support all the efforts that you've made. But we also have to hold Labour to the fire about what they will promise in due course. We, as a Labour member, I ache for you to be not the shadow minister, but the minister, and ache for there to be a Labour government. But we are not going to sit by again and watch, as the last government did, not fund the criminal justice system. And it simply will not be good enough if there are no promises. And it simply will not be good enough if you don't promise increased funding to the MOJ, because otherwise we're going to be continuing the same process that was started in 1992. And we will be continuing talking about health and safety of lawyers and the crisis in the criminal justice system.
Thanks, Raj. I think it's an interesting point with the backlog, and the need to increase court capacity almost runs directly against the need to increase and introduce a lot of COVID security measures. A lot of COVID security measures by their design might reduce capacity, for example, as you say, requiring several courtrooms for a single hearing. And I think that's quite an important balancing act, and quite important for us to consider, or for the government to consider, when making the court estate safe for its users as they reopen and return to regular face-to-face hearings. Thomas, we'll come to you. You've been quiet now for half an hour, so I think it's your turn. You have been highly vocal about your experiences as junior counsel in COVID courts, and perhaps you'll tell us in a moment, but I imagine you've been required to attend hearings throughout various lockdowns at the risk of your own health. I think I might be wrong, but I think you were the first person, or certainly the first person in this country, to use the hashtag COVID courts. I've seen you using it quite a lot on Twitter, keeping us all informed. And it was you who made the Freedom of Information request, which revealed that Public Health England had carried out on-site inspections of the cell areas at only 2 out of 79 Crown Courts that were hearing jury trials between May 2020 and February 2021, which is really quite frightening. That obviously was featured in the Law Society Gazette and I think in various other publications. Perhaps you could give us your perspective of working in COVID secure, or perhaps insecure, you might say, COVID insecure courts as junior counsel.
Thank you, Alex. And I mean, you touch on the problem. What is COVID secure? It doesn't make any sense. It's an illogical statement. There's no such thing as being COVID secure. You can be COVID prepared, but you can't be COVID secure, and it's a nonsense. And I think that's why I perhaps made the requests I made, was because I was facing prospects of certain trials taking place in certain trial centres, and I was being told not to worry, it's a COVID secure court. So I would contact the court and I would say, well, what does that mean? Can you send me some safety assessments? And first of all, I would reach somebody in the office, if I could get through to the office. That's perhaps one of the issues. We've got communication issues with all courts. Some courts are better than others. We all get that email that says, thank you for sending your email. We'll be back in touch with you in the next 5 working days. That's not much use if I've got a hearing tomorrow and I need a COVID safety assessment. So I was quite concerned that the safety assessments didn't exist. And then I was more concerned, if they did exist, you know, what were they? Were they just a general pro forma that was being applied to all the courts, or were they being properly considered in the way that you would expect for each court and for each trial? And so I made some inquiries with courts across the country. And as it turned out, you might expect there were pretty much one statement being applied to every court across the country, a kind of a box ticking exercise. That wasn't really my concern, because in the courts, you might think there are ventilation systems, there are windows that can be opened, there's open space. So there are ways and means of managing COVID in the actual court building. My main concern was dealing with defendants in the cells, because we all know what the prison estate is like. It's, first of all, it's not run by one person, one company, one group. It's a variety of private companies and the government, all of whom seem to not talk to each other whatsoever, unless they're arranging contracts. That is, they don't seem to talk about the operational issues that go on. And so my concern was, when you say COVID safety court, do you mean COVID safety court and cells? because that's quite important. And as it happens, they didn't mean COVID safe court and cells. The cells don't come into it. And apparently the cells are an entirely different consideration, not for the court service to be concerned about, which is bonkers, because if we as advocates find ourselves going to the cells to see a defendant and then going back into court, it's a nonsense to say that the court is secure, even though we're going in and out between these two places. And so I then sought the reports for the actual custody suites. Again, that was an even bigger problem, because you then have to interact with Serco and other companies that provide that service, GeoAmy in the north of England. And then you get into the whole, well, it's a security risk to give you these safety concerns. Well, it's a safety risk for you not to give me these safety reports. And I went back and forth with all manner of different issues. I was told I could attend court and see the written report, which defeated the purpose of wanting the report in the first place, to avoid going to court if it wasn't safe. Finally did get a Serco safety report, which again, as you might imagine, was just a standardized report applied to all the different Serco venues, which made me wonder, well, they've got these safety assessments, they're quite elaborate, they do deal with everything, but who's policing them? You know, if you've got a safety assessment in place and it's being ticked every week or every month as being updated, who says it's updated? If it's just the court manager going along and saying, we've got hand sanitizer in the robing room, we've got a plastic partition between counsel's row and, you know, the next part of the courtroom, which is just a nonsense with an airborne virus. But anyway, plastic partitions, tick, hand sanitizer, tick, signs saying stay 2 meters apart, tick. It was just a bit of a strange situation in just being able to self-police. So I wanted to find out if Public Health England had any input in any of this, bearing in mind we'd heard so much about Public Health England being responsible for these issues. And I made a freedom of information request, as you know. I have to say, I didn't expect that response. I'd hoped perhaps that we'd get a bit of a fuller response. I didn't expect that Public Health England would have visited every court. I thought maybe they might have on one occasion. It wouldn't be that difficult to visit every court centre once throughout the entire pandemic, but they hadn't. They attended 2 court centres, and you might expect, as is always the way with the courts, it would have been a pre-planned visit. Everybody in the whole court told, right, Public Health England are coming next week. Let's get the whole place looking ship-shape. Let's get it all cleaned up. Let's get all the signs in place, and let's present this false image of what every court across the country is like. And so we had those 2 visits to the courts you mentioned. So that was a massive problem for me, because I was concerned about whether it was actually safe to go to court in the first place. I didn't mind going to court, but I just wanted to know that it was safe. The other issue was trying to get the reports. It was a very different response from different court centres. Some court centres were very good. You get a response within 24 hours. Some I had to chase 2 weeks later, saying, you know, you said you'd respond within 5 days. I'm still chasing 2 weeks later. I took on the task of getting a report from every single Crown Court centre over the space of what I expected to be a few days. It took just over 2 weeks to get all of the reports from all of the courts, having sent the response or the request for all of those reports on one day. So how you're supposed to feel safe with a system that is that transparent or lacking transparency, should I say, lacking accountability, lacking any communication, it just doesn't give the perception of safety. So even if we were working in a safe system, which we're clearly not, how can anybody feel that they're working in a safe system when there's just no information? And I think the biggest problem for me early on was no information, no numbers of what's going on. I mean, there was no test and trace app to be used in the court buildings up until November of last year. So how you can go from don't turn it on because we've got some other system in place in the court buildings that we'll tell you about at some stage, to then in November, please turn on your test and trace app. I remember seeing a sign one day and noticing it and thinking, well, hang on, I'm pretty sure that wasn't the case last week, and it wasn't. They just changed their mind overnight, and no explanation as to what the difference was in that week. Somebody somewhere took a decision that it was perhaps a good idea to have the test and trace app on in the court centres. So for me, that was the biggest issue. I did draw together all of the issues I thought that were affecting the courts during the pandemic so far, and it is a bit of a spider's web. And I have to say, I agree with Raj and Kerry, and perhaps Alex as well, in that it all leads back to funding. The problem is one of funding, and it's not just government funding for the courts, but it's perhaps funding for counsel, for advocates, for firms, because there has been some efficient use of remote hearings. I mean, there's no doubt that remote hearings have been very helpful in many cases. There are cases where it's appropriate, there are hearings where it's appropriate. But I've seen so much frustration from judges and from court staff in scenarios where there's feedback, for example, in a courtroom. And that comes for 2 reasons. It comes because the courtroom itself is not properly fitted out. and there's a number of different microphones being left on in one courtroom because the staff haven't had any training. The usher doesn't know how to work the CVP system, funny enough, because they've never been trained in it. And so they leave on a microphone, it causes feedback. The judge gets annoyed and then refuses to list the cases the next day by CVP because he's had enough or she's had enough the day before. The second issue is all counsel are being expected then to have appropriate cameras, appropriate internet. All advocates, I say counsel because I'm a barrister, but all advocates, anybody appearing at court is expected to have an appropriate camera, appropriate internet connection, appropriate headphones, all of these different pieces of equipment. I missed the memo where they were offering a grant to all the legal aid lawyers such that we could buy this equipment. I must have missed it. And it's unfair because we're being punished. You can see that the dictate from the higher courts, and you can see what courts are doing now. They're not listing cases that should be listed by CVP simply because, understandably, it's a frustrating process when people don't have the right equipment. So it's not just good enough to fit out the courts, even though they're choosing not to do that. You also have to provide some assistance to those who are using the courts as to the equipment they've got. Not every firm is able to go out and buy the relevant equipment or have all of the relevant internet connections. I think Kerry touched on a very good point as to perhaps thinking outside of the box and reconditioning equipment, reconditioning spaces. I mean, it must be right that there are spaces to be reconditioned. And one of the things that's frustrated me the most during the pandemic is not being able to access prisoners who face very serious charges because they're not being brought to court. Cancellation of video conferences is happening right at the last minute, or in fact, you just turn up, you log in and you wait and you wait and you wait and nobody joins on the other end. And I wonder why in prisons they don't have a system whereby they can wheel a video camera system to each wing and use a room on each wing so that they don't have to be using staff to bring people to different places in the prison. I think staff shortages is one of the issues. It need not be a problem. You can have mobile CVP platforms that can be wheeled to each wing, and different wings can have different days in which you can have video conferences. So there are a number of problems. I mean, I'm like everybody else on this call. You could give me 5 hours and I'd still have things to talk about. But I think ultimately it's funding. And I think secondly, transparency and communication. The HMCTS website gives us all of these updates, but I can't find the section where we can find all the COVID safety reports. I've pleaded with HMCTS at meetings and through the COVID safety group at the CBA to give us one central resource where we can find all this information to save advocates having to waste their time, to save court staff having to waste their time dealing with these requests. But we're a year into the pandemic and there still isn't a central resource for COVID safety assessments, which begs belief.
Thanks, Thomas. I find that what you said about your inquiries about COVID safety in the cells or their risk reports, and they said that it was security risk to release those. I find that pretty amazing. But there we are. A particular problem that I've found, and I wonder if you all agree, has been overlisting, particularly in the magistrates' courts in recent weeks. This has been a recurring theme, particularly when I've been speaking to people in preparation for tonight. A lot of people have said the same thing. It's happening all over the country. I spoke to solicitors that I used to work with in Nottingham and Derby and Chesterfield, as well as London-based solicitors. And it looks like magistrates' courts are attempting to tackle their backlogs by listing huge amounts of cases on single days. Entry to the courtrooms themselves is then being tightly controlled, which is resulting in many cases in crowded corridors. Court users are often then in those corridors for very long times, often hours at a time, waiting for their cases to be called on. Just a couple of weeks ago, I was at Lavender Hill Magistrates Court and witnessed these crowded corridors firsthand. Now, the reason I mentioned Lavender Hill specifically is that Lavender Hill Magistrates Court is situated in Wandsworth, which is, as of a couple of days ago, subject to surge testing for the new, to track and trace the new outbreak of the South African variant, which has happened in the borough. That being said, I expect those corridors at Lavender Hill were just as full today as they have been for the past few weeks. And I think this problem is going to get worse, not better, because of these latest announcements about the cheerily named blitz courts, which are on the way to get through the backlog of magistrates court trials. Raj, I know you and I had similar a few months ago now, but we were at Highbury Corner in a queue together when inexplicably court admin decided to remove dozens of names from the list without telling. So defendants were turning up for court that morning. The names had been removed from the list without the defendant being informed or their lawyers being informed. And the reception area at Highbury Corner was full of a long queue of lawyers and defendants queuing for that reception desk to find out to when they had been now bailed without their knowledge, and to confirm what had actually happened to their case. And not, I mean, that behaviour on its own, and that treatment of the defendants and their lawyers in terms of not giving in the notice, that was bad enough. But then the way that it resolved itself was this queue in this crowded reception area. Right at the height of the pandemic, it was just shambolic. And I think shambolic is a word that can be used to describe a lot of HMCTS's response to all of this, unfortunately. I don't know if any of the other panelists have experienced overcrowding, perhaps in corridors or other areas.
Yeah, I certainly have. Looking over the last year, I mean, there was some shocking fiascos, which you probably all saw. One of which was this idea of, I think they called it a bucket list, where they were just, trying to blitz everybody. And, there was at one point, I think it was Croydon, there's about 35 people on the list at the height of the pandemic. 35 on a normal day pre-pandemic would have been busy, given, we all know what Croydon is like. And I don't know. I'm just having like flashbacks of just what the last year has been like. And I think the most disappointing thing is we are still having the conversations now. So I said this on a panel recently, it was not acceptable, but it was expected in April last year, because none of us knew what we had to do. We had to firefight. We had to overnight, 1 minute we were all acting normal, the next minute we all went into contingency, everyone was working from home, we had to change our whole lives. And that's fine when we're in firefighting, but we should not still be in firefighting mode now. And I get the impression that other than the recovery plan in terms of listing more cases to get rid of the backlog, because, oh no, we don't want to be seen to have this backlog because it's bad press for us, there doesn't seem to be much kind of proactivity. It is still very much fighting that fire. Now, I don't understand that, because we've all had plenty of time to kind of readjust, take stock of what happened, maybe learn from mistakes and things we didn't do so well in the first lockdown. And yet here we are having the same conversations. And like you, Alex, my kind of day-to-day life at the moment is that kind of Russian roulette as to whether your case is going to be in the next day. So that's both magistrates and Crown Court. Magistrates, we're not notified, as you said. The lawyers were certainly not notified. And we got to a point where warrants were being issued for our clients for not turning up, and they hadn't received letters. And when you actually kind of, went below the surface, these letters that were meant to be sent out, a lot of them were people that didn't have addresses, homeless people, or people that had been on RUI for a couple of years. And when the postal requisitions were sent out, no efforts were made to check that they were still at the same address. No efforts were made to contact the lawyers by the police, even though we'd stayed in contact with them regularly for updates. So the whole thing, again, it comes down to this joint up thinking, it's just an absolute nightmare. But in terms of, I'm trying to be positive, because I could just spend this entire kind of time just moaning about what the situation is like. And I told myself I wouldn't do that today, because I do that quite a lot on Twitter. But in terms of moving forward, I don't know what the answers are, because they have gone back to double listing magistrates' trials and overlisting those cases. And until they find space to put these people or come up with a better way of doing it. So, for example, if someone said to me, you know what, you've got a trial, magistrate's trial, 2 o'clock tomorrow afternoon, but you're second. So there's a good chance that you and your client won't get called on. So why can't we have a standby where, they'll know by midday, whether or not that trial is going to overrun or whether there's space in the afternoon. And most people in central London are going to be within an hour to 2 hours of that court building. Why can't we be on a standby list where someone picks up the phone from the court and says, you know what, Miss Hudson, there's not a chance in hell your trial is going ahead this afternoon, so stand down, we'll contact you with the next date. why can't we do that? And the answer is because there are no back-end staff in the courts anymore, because they were all flushed out by cuts. So instead of having what we used to have a decade ago, which was, well-experienced, knowledgeable staff that knew their courts, they knew their area, they knew their lawyers, they knew their advocates, they knew their firms, you could pick up the phone and have a chat with, Mandy in listings, or whoever it was, who would tell you that information. Now, there's this kind of like barrier between you as the solicitor with your client and the courtroom. There's this, I call it the most expensive answering service in the world. And, the biggest kick in the teeth is that the messages don't even get passed on. So we've got these kind of joke central admin teams, and it's not their fault, they're just call center workers. But that if you send an email or you make a call to these people, that the information does not get to the benches, it doesn't get to the district judges, it doesn't get to the list office at the actual court building. It is impossible to communicate. And when I was sitting we used to have a Thursday COVID meeting throughout the whole of the pandemic from April. And at one point, I was told that the courts, so they've got north and south mailboxes, and on a given day they were getting upwards of 700 emails a day. And because they couldn't possibly have got through 700 emails a day, what was happening is people like me who are trying to be efficient would give it 2 days and then would send a follow-up and do a chase-up call. So it was getting exponentially worse and worse and worse. And I actually said, if you look at the maths, look at what you're wasting in terms of money and time and resources. How much does it cost to employ a member of staff on a salary of 20 grand, 25 grand, whatever it is, to actually coordinate the communications of that courtroom? It's got to be cheaper in the long run to put back these experienced local staff over these rubbish call centres. So, in terms of, putting a positive slant on it, if there's anything we can do to help the court estate and to help the overall running of the criminal justice system, is to put the staff back in it. I mean, that would be my almost like my top want, really, is just to be able to pick up a phone or send an email without my request going into the ether. And these are urgent requests, as Thomas was saying. It's what if I need to contact the court to say one of my staff's gone down with COVID? What do I do? Do I spend all day, on hold, getting through to a call centre, which may not pass on my message? Or do I send an email, which will get lost in 700 other emails, which may never reach the court? And then who's recording that? Does someone pass that to someone to say, oh, look, there's a registered outbreak here? Is that in the statistics? I very much doubt it, given that we can't even get a basic email to the court. So, forgive my skepticism, but there's nobody there that's coordinating this. And one court manager in a building is too busy, doing the higher level stuff to be worrying about this kind of, low level communication. That's my perspective.
Well, I have enormous sympathy with the staff that are on the ground in the buildings themselves. And I think that's actually quite relevant that last month, I think it was late March, there was reporting in the BBC and elsewhere that members of the Public and Commercial Services Union at Liverpool Law Courts and Snaresbrook Crown Court have voted to back industrial action. Their union has called for courts to be closed and then reopened with regular testing of staff and increased safety measures, which would include COVID marshals and the national rollout of lateral flow tests. That union's General Secretary, Mark Savotka, said that the vote was, quoting him, an indictment of management's refusal to take COVID in the workplace seriously. Court staff have been working incredibly hard in this pandemic, keeping the justice system running, but they feel deeply let down and are worried for their safety. I mean, I don't know what other members of the panel think about. Is it likely that other staff in other court centres might vote for industrial action as well?
I don't think that's going to be the case, Alex. We actually had an indicative ballot of members across the whole country. And whilst the majority of people who actually voted did actually support the idea of industrial action across the piece, it fell below the necessary 50% of membership threshold. So that didn't go ahead, but the industrial action, the specific ones that you mentioned, did lead to an affirmative ballot. And we believe that that's why the court service eventually recognised that they had to work with PCS and others on risk assessments. And things have improved a little as a result of that, but still have quite a long way to go. But it's interesting, I mean, Kerry, you've all talked about the crisis in the courts. You've also talked about the staff, and you know, part of the piece in the Law Gazette about the trial blitz that's coming up talks about about Saturday sittings, and there are insufficient staff available in order to staff these courts. So it's all very well saying it's okay, we'll open courts on Saturdays or we'll have extended court hours, but if we don't have the staff to staff the courts, you know, it's a nonsense. And I think we've got to be very, very aware of that. And the answer is resources, but there's also issues around value as well. We've seen a tremendous amount of money wasted with the probation service of late. We've seen you know, lots of money wasted in the prison estate with some of the privatised contracts and things, with huge profits being made and an inadequate service being provided as a result. I don't know whether you wanted me to address, Alex. There's one question in the Q&A.
Yeah.
I'd be happy to address that and maybe answer 2 or 3 of the things that have been raised. Do you want me to do that now?
Sure. Yeah. I'm not sure if everyone can hear the question. Sorry, you can read the question. So I'll quickly read it out. It says the courtroom can be. This is from Sam Etchells. And thanks for the question, Sam. The courtroom can be incredibly intimidating for children and victims of abuse. Virtual court proceedings can be more accommodating for these people. Do the panel think that submitting evidence over Zoom could be maintained post-COVID?
Well, I'm sure others have views as well, but I don't see any reason why it won't be. In fact, we're going to be pressing for more activity in that area, but more than that, we want to do more advance interviews. A situation where a victim has to give evidence in court 3 years after the event, when the memory is different, and well, you guys will know about this much more than I ever will, but you can't really have the quality of evidence and everything, and so we're looking very much at how we can use virtual hearings, but more than that, proper recordings using advocates. And we're putting an amendment down to the police crime bill about advocates being used to interview people rather than police personnel. And so we think that is quite important. But yes, I would hope that we would see a continuation. But we've also got to make sure that you know, it seemed to be fair and that justice is properly served in that sort of situation. Just a couple of comments from what people have said in the discussion. Kerry, you started to talk about statistics and how variable they are. Well, the book I recommend is How to Lie with Statistics. It's a very thin book, but it will tell you how the government succeed in giving us a different picture to the one that you guys know as reality. So I should have a look at that. You also talked about the issues around lawyers not having particular adequate space to see their clients. And so I plan to, as a result of that, put down a parliamentary question or 2 specifically around that to see if we can get some information. Likewise, I think I'll pose the question about the use of porta cabins, although I think there are other products available on the market. I think they say on the BBC, to see if they've actually thought about that. Raj, you talked about income, and my colleague Carl Turner is doing lots and lots of work in that area. And I think that is important. It's not good. We can never serve justice if we don't have any lawyers. As far as assessments, and we had similar problems in trying to get information. We were told we would have to go to individual courts in order to get it. So we were relying on lawyers and others to give us information. Yes, it is about costs. It is about value, but you know, it is also the tremendous need for better training for staff. Thomas, I hope you'll forgive me when you saw me laughing when you were speaking. I was thinking about how you could write quite a farce around the picture that you were describing, because it is farcical what you were describing. You know, you can see the assessment for the court if you come to the court, but I need the assessment so that I can decide whether I want to come to the court or not. But the question I would put back to you is, what happens where you know, you consider that court is unsafe? Do you then tell your colleagues that they mustn't attend, they don't go to represent their client? You have to seek an adjournment, again slowing down the justice system. And you spoke about having a spider's web. I would be obliged if you would send me a copy of your spider's web, because I'm sure that will be interesting as well. And finally, Alex, you mentioned overlisting. And again, I intend to put some written parliamentary questions down on that. It's really, really interesting that, you know, with all these rules and everything in place, everything's hunky-dory, but the corridors are packed full of people who might not even have their case heard today. So I think I can have I'll put a bit of pressure on the government in that area as well. Thank you.
Alex, can I just on one of the things that Alex said, obviously you asked about what you do when you don't get the COVID safety assessments. Well, I returned the case 3 weeks before trial because I had specific reasons why I needed to know what the safety situation was in court. And so I returned a case, which at the time was a lucrative case for me. It was a legal aid case, and so I impacted on my own income. Thankfully, I had non-legal aid work to get on with, but there were a lot of people that didn't have that choice and had to make a very significant and dangerous decision. Well, do I crack on and put myself at risk and put those who I live with at risk and those who I reside with at risk, or do I return it and put myself at risk of financial problems because you know, there was some assistance for people, but it didn't necessarily reach all of the people that it should have reached. So the answer is a lot of people took risks that perhaps they shouldn't have had to take, which again adds on their own stress and their own ability to do the job, because people are being stretched beyond belief in this job for so many reasons, and having to take risks with your health, going to work as a lawyer perhaps isn't something that any of us thought we would have to do when we did our bar courses or our LPCs. If it was an ethics question way back when we were doing those courses, you haven't been given a COVID safety assessment, there's this pandemic, it's killing people all over the world, you're getting nothing from the court, but your client's going to be at court. What do? Do you go to court and put your family at risk? Or do you not go to court and put your client at risk of having a trial in your absence? I mean, how do you even answer those questions? And yet that's the position everybody's been put in throughout the pandemic.
And I think that's a really important point, that we've been given Hobson's choice really of what to do. I think some of you will remember that in Westminster Court, the jailer had gone down with suspected COVID the day before our advocate attended as duty solicitor, and the court staff in the cells were indicating that they didn't want to deal with anyone, but the district judge said that our solicitor had to go and deal with the matters, and solicitor phones me and I said, we're refusing, and you know, if the legal aid agency wish to sanction us because we've breached the terms of our contract, so be it. But there needs to be, as well as funding, an element of common sense being operated by all official bodies, where safety is paramount. And that has been lacking sometimes, frankly, because there is this pressure, and rightly so, there is a pressure to deal with cases. But that pressure has arisen because the systems aren't in place and the funding isn't there.
Yeah. Okay. Well, we're getting close to 7 o'clock. I said I wouldn't keep you for more than an hour. Alex, I'm really glad to hear that you've noted down a lot of what we talked about, and that's really reassuring, actually. And we look forward to seeing some written questions with some of this material in them. But thank you enormously to the four of you for joining this seminar this evening. I hope those that have been watching have found it informative as well. I think, Alex, you're our main concern. We were hoping that you'd listen to us, and you have. So thank you very much for that. And enjoy the rest of your evenings. All right.
Thank you very much. Thank you.
Thank you. Bye-bye.